Hi, this is Jason Saffold, the HR problem solver, coming to you with another video on how to have the workforce of your dreams. Well, today's topic has to do with something that is one of the most confusing aspects of human resources, particularly related to a law that's been around for 70, almost 75 years, and yet it's still one of the most confusing, most frequently challenged, one of the ones that gets us into trouble with both the IRS, the Department of Labor, other aspects of law, because there's just so much gray area to it. And that topic then is the Fair Labor Standards Act and its application towards independent contractor or employee status. Well, the Department of Labor and the IRS try and paint this as a very simple decision to make. There's 3 factors, and of those 3 factors, there's even 20 question tests that you can apply to any worker situation or relationship and determine, quite simply, if this is an employee or an independent contractor. But I beg to differ. It's not that easy. What happens if you have 10 questions answered employee, 10 independent contractor? What if it's right there in the middle? What if it's just so gray that you can't even answer 5 of the questions and you're left with 15 and some of them lean independent contractor, some of them lean employee? Which way do you go? Well, I'll tell you, when it gets down to that nitty-gritty, that fine-tooth comb, even my advice may not be the final word for you. You may very well want to consider going to an employment attorney who's going to make sure that you absolutely 1,000% fall on the right side of the law. But I'll tell you, with the simple application of the 3-factor test and 20 questions, in the way that I see it, and the way that I've guided so many companies before, you're going to feel pretty safe in being able to apply this and know that you're doing the right thing. Now, quite simply, the very first thing that you should think is, if your motivation for trying to make a worker an independent contractor and not an employee is to avoid workers' compensation or to avoid unemployment costs, then you're probably actually needing to qualify this person as an employee. So if you're thinking that, if that's your motivation, be prepared to actually take some additional steps to treat the behavioral relationship with the employee worker differently so that they truly can be an independent contractor. Now, that being said, the 3 factors that I talk about, the one I just referred to is behavioral control. In behavioral control, the question is, does the organization have a right to direct the activities of the worker and how they do their tasks, how they've been instructed, or how they've been trained? If you, the organization, are directing that training, if you're instructing them to do this task in a particular way, if you're controlling what is the outcome of the work, very likely this leans towards an employee-employer relationship. Now, the second factor, as we now begin to muddy the waters, is the financial control. Does the organization control business aspects of the workers' jobs related to or including unreimbursed expenses or investment by the worker? And does that worker stand a risk to lose money? In other words, is there a profit or loss relationship? If the worker can lose money, in other words, they're investing their own time, their own money, their own tools, their own materials, their own products into the project, without knowing what that final payoff is, there's a chance for them to lose money. It's a profit and loss risk that leans them heavily towards being an independent contractor. If, on the other end of the spectrum, you are reimbursing them for their travel, their hotel stays, There is a certain amount of money that's getting paid for the project, and all they truly invest is their time. You're leaning towards an employee relationship. So it's kind of looking at where does that lean. Now the last situation to look at is the relationship control. Does the organization imply a long-term or indefinite relationship? If so, that's like an open-ended employee relationship, an at-will employment, if you will. I've seen some companies who have called an independent contractor so, but they even have a disciplinary process of 3 strikes, you're out. You make this mistake, you make that mistake, the third one, your contract is over. But in reality, it's like a council-worn discipline, terminate type of performance management procedure. In that type of relationship, relationship control, the organization has that power. They expect that the employee, the worker, is interested in returning year after year, month after month, for additional opportunities. This again also leans it towards employee control. One of the questions I get asked frequently in this regard is, well, this person, they don't come to our office. They don't have a desk. We don't give them a phone. They sit at home to do their job. Doesn't that make them an independent contractor? No. In fact, the Department of Labor issued a particular fact sheet just to say that that isn't germane to their decision-making process. It's one of the 20 questions, but it carries so little weight. To them, it's not even germane, as though it shouldn't even be one of the 20 questions in the first place. So therein lies the rub. As you go through these 20 questions, it's also hard to understand where does the Department of Labor put the most importance, the most impetus. They don't rank the 20 questions and say, these 5 are the most important that we consider, these 6, mediocre, and these 7, not as important. They don't do that. Wouldn't that be so simple? Instead, you're left with a little bit of a guessing game. And so that is where I urge you that if you're on the fence, if you're 10 and 10, or if it's even 12 and 8, and it just looks like some of the more important questions, how are you directing the work? Are you controlling it? The financial aspect, do they risk losing money in the situation? Are you paying benefits? Are you implying that there's a long-term relationship? You may need to lean towards employee so that you're not at risk of being fined by both the IRS for avoiding taxes, the Department of Labor for not taking care of workers' compensation, for not taking care of SUDA and FUTA and Social Security and other things. Don't put your company at risk if you're on that fence. If anything, as I mentioned before, there are some simple things that you can do to ensure that it is an independent contractor and that risk is there for the employee. The lack of direction, so to speak, is there for that employee. It's up to them to get the right outcomes, that they need to bid on projects, that they need to renew their contractual interest in the organization. Those type of things can help you push towards independent contractor. I'd be happy to help you in the future work through these issues if you're ever interested in contacting me directly for that type of consultative guidance. Otherwise, I hope that you feel that I've made it a lot simpler, a lot more clear about how to then determine if your worker relationship is independent contractor or employee. So that's another way to ensure that not only do you get to the workforce of your dreams, but you keep the workforce of your dreams. The HR problem solver here, trying to help you get the workforce of your dreams. This is Jason Saffold. Thank you for listening. I look forward to seeing you in another video.